Michael Popok, Legal AF After Dark. This past Saturday on Legal AF, the leading podcast devoted to law, politics, and justice, Ben Meiselas and me, two co-anchors, two co-founders, talked about what's going on in the DC election case and and in addition to that, what's happening with other cases against Donald Fraud seeking damages in civil cases brought by victims of the Jan 6 insurrection, like the estate of Brian Sicknick, the late, great police officer, Capitol police officer, died in the line of duty. Judge Mehta made some rulings about whether Donald Trump has to face those charges, face that music, and Ben and me talked about it here on Legal AF. Take a look.
I didn't want to ignore two other developments in Washington, D.C. that we've been covering here. One is Donald Trump's request of a stay before Washington, D.C. federal judge Amit Mehta in the civil lawsuits, including for wrongful death and for other civil claims arising out of the January 6th insurrection. Donald Trump saying, well, because of all these criminal proceedings taking place and the potential need to invoke my Fifth Amendment rights against self-incrimination, the civil cases should be stayed pending the outcome of the criminal case, to which federal judge Amit Mehta said, well, it's premature at this stage. Why don't we wait until your deposition, Donald Trump, and see if you're going to invoke the Fifth. At this stage, let's see what you do. You're potentially testifying in other places. You say you want to testify, so why don't we see what happens and then bring this motion at that time? And then an important D.C. Court of Appeals ruling in the D.C. Circuit that has massive implications on the Department of Justice prosecutions of insurrectionists and Special Counsel Jack Smith's case against Donald Trump. Popok, what went down in both of those cases?
Yeah, I think we've got a really consistent ruling from Judge Mehta. He's the judge that presided, just as way of background, over the Oath Keepers trial and the conviction of Stuart Rhodes and the others for seditious conspiracy. One of the things that's interesting about the DC Circuit bench is that all the judges, Republican or Democratically nominated, have tremendous depth of experience about all things Jan 6. There's not a judge, including Judge Chutkan, that hasn't tried either by bench trial or presiding over a jury trial or handling sentencing or civil cases related to it. They've all each tried dozens of cases and know the facts of the case very, very well. And while there's been some of the judges we haven't completely agreed with early on, Judge Nichols, who handled the Steve Bannon case, did some strange things and some other strange things about obstruction of Congress as a count, which I'll talk about next. But by and large, almost all the judges in the D.C. Circuit Court have done the right thing. We may disagree on the periphery about how many years they sentence somebody to, but really, except for an occasional somebody who got let off who should have been a misdemeanor, everybody is handling these cases, knows these cases well. Amit Mehta is also, because when you're a federal judge, you preside over criminal cases and civil cases, same docket, law and equity. You do it all when you're a federal judge. He's also the judge that's been assigned a series of cases brought by DC Metro Police, Capitol Police, the estates of Capitol Police who died, like in the line of service, like Brian Sicknick, and even House of Representatives members. They're separate cases, but they're all, to continue with our consolidation theme here on Legal AF today, they've all been brought in front of the same judge, Judge Mehta. And in earlier attempts by Donald Trump to assert that case we just talked about, Nixon versus Fitzgerald, to say, I can't be sued civilly in damages like ever. Even there, Judge Mehta said, no, there's outer boundaries to your immunity, even under the Nixon precedent. And I think you have gone beyond the outer boundaries of your immunity in your involvement. This is the judge when he wrote his decision about those prior cases brought by the Metro DC police for damages, claiming that their civil rights were violated. And under the KKK Act, it is what you think, that Donald Trump is responsible for what happened on Jan 6, to the carnage that happened inside the Capitol and around the Capitol, and the people's whose, especially the police and House of Representative members and others whose lives are forever impacted emotionally and physically, and even with their own lives. In the case of Brian Sicknick, because of Donald Trump lighting that fuse and directing those actions of his followers, the "won't someone rid me of this meddlesome Congress certification" comment, to continue our theme today of history, made by Donald Trump, which was taken up by thousands of his followers who stormed the Capitol and our seat of democracy. So Judge Maida had already ruled on that months ago. What was before him this time was a similar motion brought by the estate, by Donald Trump against the case brought by the estate of Brian Sicknick. That's the police officer who battled valiantly on Jan 6, was pepper sprayed and bear sprayed, and suffered a heart attack the following day. He was a very healthy 40-something police officer. He would not have died but for Jan 6th and Donald Trump. That's the argument. And his family sued for similar damages under those similar statutes and civil rights violations. And so Donald Trump brought the same motion that he brought there. And Judge Maida basically said, for the same reasons I found previously in the related cases, that you've gone beyond the limits of absolute immunity, and you're not entitled to avoid, on these facts, you're not entitled to avoid absolutely the civil case. Donald Trump said, can you at least stay my case here and not let it progress while the appellate court, the D.C. Court of Appeals, decides whether the issue that's before them that hasn't yet been decided about whether my immunity does prevent this kind of case. And the judge said, no, that's kind of premature. We're not that far along in this case. We'll see what happens in your criminal cases. Judge cited to his criminal cases. You haven't made the decision whether you're going to waive your Fifth Amendment rights there. That's for another day. So the judge just took the can and just punted it, just kicked the can down the road and said, come back to me if a number of things happen in the future. If you win your appeal on the issue, of course, come back to me. We'll talk about the impact of that on this case. If you waive your Fifth Amendment rights, or you don't waive your Fifth Amendment rights, or the trial has or hasn't happened at the time this case would be moving to trial, and a civil side, come back and talk to me. But I'm not staying a darn thing right now, and I'm not dismissing the case while we're waiting for the Court of Appeals to rule. So that was on Judge Maida. On the obstruction case, the import of that is the following. The highest level charge that the Department of Justice used against any Jan 6th insurrectionist to date is seditious conspiracy. That's what the Proud Boys leadership got. That's what the Oath Keepers leadership got, and a handful of other people. It was the giant cudgel that the Department of Justice also used in their plea negotiations, several people pleading guilty without a need for trial already to seditious conspiracy. That had the highest dollar amount on the board for the years in prison, and that's the one they use. The second highest charge in their arsenal, the Department of Justice indicting arsenal, is obstruction of Congress. And obstruction of Congress sounds exactly like what these people did. They went down to try to stop the certification of the electoral vote on purpose on Jan 6th. That's the reason, just to remind everybody, that's why they're there on Jan 6th. They're there and stormed the Capitol to stop the certification, right? They were calling it stop the steal. We call it stop the peaceful transfer of power and the certification of the election. That sounds like a lot like you're obstructing Congress from doing their functions. A couple of judges, yes, they were Republican appointed and Trump appointed, including Judge Nichols, took a look at that indictment and thought that the Department of Justice had overcharged the case, meaning they had picked criminal counts that didn't fit just to kind of ratchet up the numbers, and dismissed obstruction of Congress. Judge Nichols particularly observing that he thought it only obtained, and you could only use it when they literally got their hands on the certificates and the paperwork that was being considered by Mike Pence at the podium. That's the only way you could have obstruction of Congress, because of the electoral certificates involved. We all thought, and we did hot takes on this, we did legal AF analysis on this, we all thought that was ridiculous, that can't possibly be the only obstruction of Congress that could, you got to rip up the certificates like in the face of Mike Pence and throw it at him. That's the only way you can get charged. And no other judge believed that. There was a couple that did. Now it's definitive. The bosses of all these DC Circuit Court judges is the DC Court of Appeals before you get to the Supremes. And a 3-judge panel voting 2-1 led by Judge Pan, and a shout out to Judge Pan. She has made some very important rulings in favor of democracy against these Gen 6 insurrectionists, like time and time again. She is if I'm doing the pool for who could be the next Supreme Court justice for Joe Biden, I think it's Florence Pan. But I'll just leave it at that. Keep an eye on Florence Pan, the way we kept an eye on Ketanji Brown Jackson, Amy Berman Ketanji Brown, Amy Berman Jackson. There's a few of them that Tanya Chutkin, who, if there's ever an opening at the Supreme Court level, these could be nominees for Donald Trump. And Judge Pan, writing for the court, rejected a Jan 6th insurrectionist who is trying to lower his sentence. He'd already been sentenced to over 6 years because he was in the first wave that broke into the Capitol at the moment they were about to certify. Literally the tip of the spear, using a giant walking stick. And he was a police officer. He was not only a Marine, he was a cop, a sergeant at the time. And he and others were the first ones in, as the legislators had to be belly crawled out and protected by Capitol Police, outnumbered Capitol Police. And so he said, well, no, that's not obstruction of Congress. And his main argument was that there's an interesting word that Congress used when they made the statute that animates the statute. And it's the word corruptly. What does corruptly mean? And you'd think, people watching the show, isn't everything already defined in law? Don't you go to a giant dictionary, legal law dictionary, and you go corruptly, and there's a defined term that everybody agrees on? And the answer to that is no. Congress uses terms. Sometimes you can go look at other times Congress used that same term somewhere else and how courts have interpreted. Or sometimes courts will refer to the dictionary definition, Oxford or any of the dictionaries, Webster's, and say this is what it means. So statutory construction and interpretation is very, very important. He argued that the defendant argued in order for him to be convicted of corruptly interfering with Congress, he had to do it through dishonest means. And since he held the belief that the election was stolen and he didn't really do anything dishonestly, he did it intentionally, but not dishonestly, he should be let go. And Judge Pan for the court said, no way. Corruptly means wrongfully, with intent, using criminal means. You used a giant stick. You attacked Capitol Police. You broke in on the first wave. You are exactly what obstruction of Congress was meant to punish if you violate it. And so now we have a definitive ruling at the DC Court of Appeals level going forward about that, yes, obstruction of Congress is an appropriate count to use, which means all of the people that pled guilty to that don't have an ability to an appeal because a higher court has ruled, and all the people that got their prior counts dismissed by lower court judges could be re-indicted by the Department of Justice. If they don't like the way that went, they could now be re-indicted under this new count. It wouldn't be double jeopardy because that count was dismissed, and they could be tried again and sentenced again. And I don't know. I think the Department of Justice has to look to all the people who were able to convince judges that count should be dismissed, and they may reactivate those counts against those very people. Great ruling by Judge Pan, and it'll stay on the books unless and until it's taken up to the U.S. Supreme Court and they make a different decision.
And it will be taken up to the Supreme Court, and the Supreme Court will at some point in the next year, 2 years, max, maybe 3 years. I think sooner we'll be making a decision. We will be here on Legal AF. We will look back at this video, and we will, when the Supreme Court grants certiorari on it, and there's oral argument on it. So I think that is something that will take place, and we'll keep you posted. But that's why it's important that we follow this at every stage of the process.
All right. If you like that kind of hot take, that kind of interaction between two practicing lawyers who can explain it to you, because we practice in courtrooms and courthouses just like the ones we report on. I've been doing it for 32 years. Come join us every Wednesday and Saturday night at 8 p.m. on YouTube. Or if you're more of an audio podcast person, we put that same podcast on audio platforms like Apple, Spotify, Google, and the like. If you know about us already, welcome back. Glad to see you. If you don't know about us, hey, This is what we do, only on the Meidas Touch Network. And if you know about us already and you want others to join, you've been trying to sell them on becoming a follower, a listener, a part of our audience, take that clip I just did, send it off to friends and family and tell them to join us on Wednesdays and Saturdays. It's well worth it. Until my next hot take, my next legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.